Okay, good morning everybody and welcome to Wednesday's online seminar. Today we're looking at the trouble with subcontracting is, and this is presented by Richard Silver, who's the senior partner. As always, Richard is happy to answer questions from you. If you could use the Q&A or the chat tool in the bottom toolbar, and he will answer as many of these as possible at the end. And again, as always, if there's something you don't particularly want to raise in an open forum, please feel free to email Richard directly, richardsilver@silverllp.com. His email details are on the slides, should you wish to avail yourself of that facility. Okay, without any further ado, Richard, let's start. So over to you.
Thank you, Julie. Good morning on this beautiful Wednesday morning. We're going to deal with subcontracting today. As many of you will know from who have attended my previous seminars, my background is in construction. I held the role of both Chief Surveyor and Construction Director, ultimately towards the latter part of my construction career, but was a surveyor and a site agent and a contracts manager. I've never acted as an employed person for a subcontractor, but we did deal with subcontractors quite obviously, and looking back, maybe not always fairly. What we're going to cover today are some basic principles concerning construction contracts and things that subcontractors should be aware of. It equally will apply to contractors, maybe looking at things that they could take advantage of. The starting point, as is always the case when dealing with construction contracts, is the contract. It is my experience that on many contracts, there is a subcontract in place, not always, but in the main, but they're not always signed. And therefore there can be dispute as to what are the terms of the contract. And I think the starting point is to actually consider what is the relevance to the contract, because I think lots of people just simply do not place enough emphasis as to what they are signing up to. So the contract basically sets down the obligations of the parties. It deals with, in the first instance, the parties' respective obligations, what they should and should not do. And to give you an easy example, we have the JCT minor works form of contract. And if I had one that I could show you, you would see it doesn't go to that many pages. But then if I get out the JCT with contractor's design version, it's much thicker. So why is one much thicker than the other? Because it sets down procedures dealing with a lot more issues. Because the minor works is meant to be for minor works, and the with contractor's design is covering for works that are far more onerous, far more complicated, and therefore needs to include provisions dealing with situations. Now, when a particular problem arises, ideally you want to be able to open up the form of contract, read it, and see what it says you should do in those circumstances. Where the contract is silent, you will therefore have to look at the common law, in other words, case law, to establish what happens. And that can be complicated and uncertain. So it's far better to have within the contract bespoke clauses or clauses dealing with the possible eventualities that the parties may face. Now, on that basis, it is my view that there is no one contract out there that will exactly fit what you want. The NEC, which you will know if you've listened to my seminars, I am often critical of. One thing I particularly like in the NEC is it has Z clauses. And Z clauses covers any amendment to the other clauses. It recognises that the contract as drafted in its standard form is unlikely to exactly match your requirements, and therefore you're going to amend it. And it's my view that you always need to amend a contract. Now, those of you who are main contractors will be only too aware that it is a very rare occurrence where you get the main contract and it is unamended. In some cases, it seems almost that the amendments are more than the original base contract. So then the question is if we've got these amendments. Why are they there? And why would we use, for example, the NEC as opposed to the JCT? Or why should we use the JCT standard form rather than the design and build? Well, what the contract is effectively doing is allocating risk. So if we look at the design and build contract, not only is it setting down the procedures that you are to adopt when a contract is in place. So, for example, if you are being delayed, the reason you have to issue an extension of time notice is because the contract tells you you must. So it's setting down the procedures, but what it's also doing is allocating the risk. And the risk is all too often amended as part of the revisions to the contract. So let's look at one of the main areas, which is design. Under the JCT standard form and the subcontract, if you use the JCT subcontract to pass down those provisions, the contract provides that the contractor, and hence when passed down to the subcontractor for the development of the design. But what they're not responsible is the base design upon which they are to develop. So the employer has initially gone out and worked out their employer's requirements. Under the standard form, the employer remains responsible for those, and thereby the contractor, when placing their subcontractor, remains responsible for those. But all too often that is revised. And what is done is instead is to make the contractor or the subcontractor responsible for the totality of the design. So when establishing there is a contract in place, quite often the effect of having the contract in place is to make the provisions applicable to the subcontractor hugely more onerous. But as we've identified, quite often the subcontract is not in fact signed. So if it's not signed, is it applicable? Is there a subcontract in place at all? And this is one of the most common problems faced by subcontractors, and particularly when I'm involved, more often than not, the very first action I've got to do is to actually find out and establish what is the subcontract. And what we need to look at is the basic principles for contract formation. It's very simple. In order to have a contract, you need to have these 4 elements. There must have been an offer. That offer must have been accepted. There must be consideration. And there must be an intention to create legal relations. Now, I'm just going to quickly deal with item 4 now, because that will nearly always be in place. Now, what that means is that when the parties have entered into the contract, they expected or intended that the contract they've agreed to would be enforceable through the courts, as opposed to what is often referred to as a social arrangement. So if you agree something with your wife or husband, that will generally be believed to be a social arrangement. You can't enforce it through the courts because you never intended it. But clearly, when the parties are not related, as in between contractors and subcontractors, it is almost automatically assumed that there is legal relations. What we're now going to do is deal with offer, acceptance, and consideration. So far as offers are concerned, the simple thing is we must distinguish between what is an offer and an invitation to treat. An invitation to treat is when the contractor, for example, goes out and seeks tenders. What the contractor says is, dear Mr. Subcontractor, please can you submit your tender based upon X, Y, and Z. And what generally comes back is something completely different. Most likely what the subcontractor says is our price is £1 million based upon our terms and conditions. So they haven't even priced it based upon the invitation to tender. Now, the invitation for tender has no relevance because it is not an offer. It is the subcontract's tender that is the offer, and which, if accepted, will create the contract. And the most key point therefore, will be that it will be the subcontractor's terms and conditions. One problem that arises when dealing with offers is how long do they last? And this was one of the first ever problems I got involved in when I started my construction career. What had basically happened is, as part of the tendering process under the main contract, our estimating department had gone off and got lots of tenders from subcontractors and suppliers and had created their tender based upon those quotes. We were then successful in obtaining the project, our contract was placed, and then all the files were passed down to the surveyor, in this case me, and I had to go out and then place orders with the subcontractors. One of the tenders that was included within our quote was one that was extremely low when compared with other subcontractors. I approached them and said, right, we'd like to just negotiate on your price. And they came back and said, yep, it's been doubled. And I said, well, but you've quoted for this. So I'd like to place order with it. Well, no, we're not willing to. We want to double our price. And the question is whether they could do it. And the simple answer is yes, they can. Because it is an offer, it can, in theory, be withdrawn at any time before acceptance and will generally last for the period stated within it. So if the tender states it shall be open for 6 weeks, not difficult to work out, it will be open for 6 weeks. But if it is silent, then it will be open for what is termed a reasonable period of time. And in determining what is a reasonable period of time, the courts will look at lots of things, for example, its value, what it relates to, etc., etc. But basically, a party can withdraw their tender within the period it said it was open for acceptance. So if I submit a tender saying it's open for 6 weeks, I can withdraw that offer at any time, including before the end of the 6 weeks. There is, however, one exception. And that's when the submitting of the tender is a contract in its own right. So if I ask you to quote for the works, and I ask you to make sure that your tender remains open for 6 weeks, and that I will pay you £1 for doing it, and you then do it, we now have a contract. Mine was, my initial request was an invitation to tender. By you submitting your tender in accordance with what I requested and me then paying you the £1 creates a contract, and that tender must therefore remain open for the period stated and agreed. Okay, as we're going to deal with in the moment, in order to create a contract, there must be an offer and an acceptance. But what more often happens is that there is not an acceptance, but there is a counteroffer. So let's go back to our example. The contractor sends out their invitation to tender, saying that the tender shall be submitted in incorporating the main contractor's subcontract terms. The subcontractor submits their tender and says on the back of its terms that its terms will apply to the tender. Having received the tender, the contractor then sends an acceptance, but stating its terms apply. Well, it's not an acceptance. Even though it says on the top of the form, subcontract order, it isn't a subcontract order. It is a counter offer. And as soon as a counter offer is issued, it is a rejection of the previous offer. So let's just apply this very simply. Subcontractor submits his tender saying its terms. Contractor issues its subcontract order stating its terms. That tender can now no longer be accepted. It's been rejected. It's come to an end. And there's the case that dealt with it, an old one, Hyde versus Wrench. What happened was, if memory serves me right, a person was selling their farm. I think they wanted £100 for it. Someone offered 90. They rejected it and said, no, not interested. So they then said, oh, I will buy it for 100. And they said, no, don't want to sell it to you anymore. Went to court, and the court said, you can't accept it at 100 because you've rejected it by offering the £90. So we've dealt with offer. We now must deal with acceptance. And as far as acceptance is concerned, there is 3 forms. acceptance in writing, oral acceptance, or, and which often happens on construction projects, acceptance by conduct. Now, the important point is that the acceptance must exactly fit the offer, because as we've just identified, if it doesn't match the offer, it's not an acceptance, it's a counteroffer. Now, so as far as written is concerned, you get a subcontract order and you receive it, and there's an acceptance form at the back, and you have to sign it, you sign it and return it, you've now accepted. But if you sign it and then add a little term, subject to our terms and conditions, above your signature, you've now made a counteroffer. The next form of acceptance is oral. You've said to me that you are offering £10,000, or you submitted a tender of £10,000, and I phone you up and say, I accept, start tomorrow. I've orally accepted. There is no problem with having an oral acceptance, with the exception of having to prove it. Clearly, it's much easier to prove written acceptance than oral acceptance. Now, the final form of acceptance is conduct. I'm just going to deal with conduct in a moment. Just Neil to do this. As far as acceptance is concerned, there must be a reasonable degree of certainty, because quite often it's not as clear as parties would like when the works have started on site whether they've agreed. And what the courts will look to do is to establish what has been agreed, because there can be no contract if they don't understand what has been agreed. Now, as far as conduct is concerned, again, let's go to our standard scenario. Invitation tender is issued stating main contractor's terms and conditions shall apply. Subcontractor submits their tender stating their terms and conditions apply. Contractor submits their subcontract order stating their terms and conditions apply. And the works are ongoing on site. Well, where's the acceptance? Well, the argument is that subcontractors on site, they're carrying out works, they must have accepted by their conduct. Okay, if that's right, what we need to do is to establish what has been accepted. And although it sounds obvious, an acceptance must follow the offer. You can't accept something that you have not received. So if you're going to state that a party by starting works on site has accepted an offer, you must establish that the offer was issued before they started on site. In other words, if the main contractor issues the order after the works have actually been started on site, you can't have accepted something you had not received. It's impossible. But then the argument goes, but you've continued. But that's not going to be sufficient for acceptance, because they haven't changed their position. And silence is never acceptance. So if you've issued the subcontract order post the subcontractor starting on site, you have to show that something that the subcontractor has done indicates that they've accepted. An example of that might be, for example, where the subcontractor starts issuing letters stating and referring to certain provisions within the contract. So you may have the strange situation that the subcontract order is issued after the subcontractor that started on site and hence is not applicable. But then by the subcontractor referring to clauses within the contract, they have by their conduct accepted. Now, one thing we must identify, however, is there can be conduct and conduct can be acceptance. So let's give this situation. Subcontract order has been issued. Subcontractor goes back and says, sorry, we don't accept your subcontract order. We maintain that our terms and conditions should apply. And then the subcontractor starts work on site. By the subcontractor sending their letter saying they don't agree to the subcontract, they've rejected it. So the subcontract cannot possibly be in place. But the subcontractor suggesting that their terms apply has made a counteroffer. By the contractor allowing the subcontractor to commence on site, the contractor has accepted by conduct the subcontract terms. And this whole scenario is often referred to as the battling of the forms. And it happens more than you would believe. And quite often, it can be of huge significance because quite clearly, the subcontract terms are going to be far more beneficial to the subcontractors. And quite often, they will have exclusion clauses and limitation clauses for delay and other matters. And indeed, if you're dealing with things like lift companies and piling companies, those terms can be extremely favourable to subcontractors. So this is the biggest issue that arises generally on construction contracts with subcontracts, is what is the subcontract? Simply because there is no signed order and one needs to deal with acceptance. This will also apply similarly to supply orders, because quite often there is uncertainty in regards to those. And quite often suppliers, when delivering materials to site, issue a delivery sheet which says their terms and conditions apply. But if there's already an order that has been put in place, they don't. So again, let's just go through that. You submit an order for some materials or some supply. The supplier delivers them to site. By so doing, they've accepted the supply order. By issuing their delivery note with their terms and conditions applied, it's all too late because the contract has already been formed. What we now must look at is consideration, and I've got a few slides that follows this one dealing with some cases. It's a very strange first statement there. Consideration must be sufficient, but need not be adequate. Surely sufficient and adequate mean the same, don't they? I'll give you an example. It's a fun case, not if you were involved, no doubt. What basically happened was a husband and wife separated, and the husband went off with a younger woman. The husband contacted his wife and said, "Darling, would you be so kind as to sell my car for me and send me the proceeds so that I can go off on my holiday with my new girlfriend?" The wife, obviously looking back at the good old days, did what her husband asked. And she did, in fact, sell his car for £1 and sent him the £1. The husband was, to say the least, disappointed, and they went to court as to whether or not the sale has gone ahead. And what the court said was that the consideration was sufficient, but not adequate. In other words, for consideration, it doesn't have to be fair. All it has to be is something. And you will have heard the term for a peppercorn. So if I agree to build you a house for a peppercorn, that peppercorn might not be fair payment to me, but the contract is nevertheless enforceable because there has been some consideration. Now, consideration doesn't have to be monetary. It can be many things, anything of benefit to you or anything that is detriment to me. And there must be two forms of consideration. Each party must perform or provide some consideration. So under a construction project, my obligation to carry out the works is my consideration. Your payment to me is your consideration. Your consideration may be that rather than paying it to me, you're going to pay it to someone else who I've asked you to pay. That's still good consideration. But it doesn't have to be fair. And more often than not, I would suggest to you under subcontracts, they're anything but fair. Because in the majority of times, the subcontract obtains the contract because they've underpriced it or are lower than the next best tenderer. So you can't get out of a contract because it is unfair, you've underpriced it, provided there is an agreement, an offer and acceptance and consideration, the contract is enforceable. But we're then into the situation of pre-existing duties. So I'm on a job And there's a contract in place that says that I am to be paid £100,000 for doing the work. I've done the work and I'm owed £100,000. And then the employer says, I'm not going to pay you. And you say, why? And I say, well, I just don't want to. Now you're in financial difficulty. And I say, well, I know you can't do anything about it. I'll tell you what I'll do is rather than pay £100, I'll pay you £70. Well, you're forced to agree to it. You sign an agreement saying that, and then I give you the £70. There's a new contract in place, surely. You can now not recover the additional money. The answer is, it is unlikely that contract will be enforceable because there has been no consideration. The reason is that you have paid, or I've paid you £70 of an existing duty to pay £100. So there is no consideration for me. And as a consequence, that agreement would not be placed or would not be in place. There are exceptions, however, where I have paid you early. The fact I've paid you £70 today, rather than £100 in a week's time, I've provided you consideration. I have done something additional, and that's what we need to look at. Now, in the case of Williams versus Roffey brothers, this concerned subcontracting works for carpentry. And what the main contractor did was to ask the subcontractor to undertake the works that were under the original contract. So there was a contract, and the carpenter had to finish certain works by, let's just say, the end of next week. Because there was concerns about them being out to complete, the main contractor effectively offered them a bonus to complete by next week, the original obligation. The subcontractor agreed, completed the works by the following week, and then the main contractor said, well, I'm not paying you now because there's no consideration. The courts disagreed because under most contracts, whilst there is a completion date, the subcontractor doesn't actually have to complete by that completion date because the contract provides for damages if they don't. It provides for extensions of time, thereby identifying that you don't have to complete by the completion date, recognizing that it might not occur. So under the contract, the subcontractor has a right to complete late, but will be in breach and has a liability for damages. Now, those damages of finishing 1 week late could be £30,000, but trying to accelerate to complete on time could, in theory, cost the subcontractor £40,000. So in that case, there is likely to be a contract, and that's what happens in Williams versus Roffey brothers. We've got the case there. In penal about paying early is of benefit and can be considered as being consideration. The case of DC Builders versus Rees is the very dispute where the employer was rather nasty, said accept this in full and final payment, and if you don't, I won't pay you anything. It was decided that there was duress and coercion and no consideration, and therefore that payment, the contractor could seek the recovery of additional payments for the amount that had not been paid. So we've now dealt with contracts. We've identified that to have a contract in place, we must have an offer and acceptance and consideration. We must have clarity as to what has been offered and what has been accepted. Now, if we've got an offer that is uncertain, which has then been accepted, so it is uncertain as to what has been accepted, it may be the case that there is still no contract because the parties cannot identify what has been agreed. Equally, there may not be a contract because there has been a letter of intent. And I wonder how often jobs start, projects start, contracts or the work start before an order in place. Now, a letter of intent is a letter that can be in a number of forms. It generally says something like this at the beginning. It is our intention to enter into contract with you. In other words, it infers that they're not doing it now. They're going to do it in the future. So it's intent, what we intend to do sometime in the future. It then proceeds to state why it's in the future. it may say is because at present we've still yet to agree the terms of the contract, or we've still yet to get authority, or we've still yet to secure the main contract. You know, particularly where a letter of intent is issued to the main contract, it's not uncommon for a letter of intent to be issued to a subcontractor. There may be loads of reasons why there is an intention in the future. The letter of intent then goes on quite often to say there is some form of cap. For example, it says, please commence work on site up to a value of £100,000. And that's different than what the tender value is. Or it can say, please carry out the initial enabling works, or please carry out the works for the first month. What it's doing is it's asking you to do an element of the work, but not all of it. What it then quite often says later down the form is that we shall seek to place the relevant contract in place and it shall have retrospective effect. In other words, all the works that have been covered or carried out under the letter of intent will be ultimately undertaken under the contract once the contract is in place. By the referring to retrospective effect, again indicates that the contract is not initially in place. It then finally says that in the event that you do not, or we do not enter into contract, you shall be entitled to be paid a reasonable amount, and you shall have no right for loss of profit, etc., etc., etc. By this nature of works, it is in identifying you are not in contract. And this is something that is quite unusual and people just don't seem to want to agree, but it's very simple. If there is a cap in the contract, or sorry, a cap in the letter of intent, it can't be an acceptance of the tender or a contract because it is not allowing you to carry out all the works. So what's the significance there if there is such a letter of intent? Well, if you've got a cap in the scope of works, you're only able to carry out the works for the first month or up to £100,000, or just the initial enabling works, there can be no completion date. And if there is no completion date, there can be no liquidated damages or indeed general damages for delay, because you cannot have failed to complete works if you're not allowed to carry them all out. There can also be no provisions for extension of time because there is no time to be extended. There is also no commitment to complete the works beyond the cap, and the subcontractor would be entitled to a fair and reasonable amount for the works, and not necessarily what they've tendered for. It is extremely significant. I have been involved in jobs where a subcontractor has called me up on what is a very big job saying, we're 9 months down the line through this job, we're losing an absolute fortune, we're way, way behind program, and unfortunately, in the main, it's our fault. And what I've done is I've gone down to site to discuss with the subcontractor what's happening. And what we've identified is that the invitation to tender and what was intended to be the contract was very onerous, and that every risk was passed down to the subcontractor. The subcontractor, when tendering in the 2-week period they had, failed to pick up all these points and hadn't priced for them. So in other words, all these delays, all these additional costs would be down to the subcontractor if there was a contract in place. But rather than placing the subcontractor, because the main contractor hadn't received a contract, they'd issued a letter of intent to the subcontractor saying, it is in our intention to enter into subcontract with you. We shall, at some time in the future, be placing a contract with you. But in the meantime, proceed on the basis of you had to carry out the works up to £1 million. If and when the contract is entered into, this will have retrospective effect. Well, the simple point is it hasn't happened yet. And we've already identified that a party can withdraw their tender any time before acceptance. But it hasn't been accepted. So they can therefore withdraw their tender. There is no contract in place. There is simply what is called a simple contract. And what happens is that there is an entitlement to quasi-contract. It's an area of restitution where the subcontractor is entitled to a reasonable amount. Now, I wonder how many of you have been on projects where there is a letter of intent, and when submitting your applications, you've submitted them on the basis of quantum merit. It very rarely happens. Everybody assumes the contract is in place and the main contractor and subcontractor make their applications based upon their tender. But the reality is that's not their entitlement. That's their entitlement if and when the contract is entered into. And if the contract is not entered into, they're entitled to quantum merit, a reasonable amount. It is my belief that in most circumstances, it is far more beneficial to be under a letter of intent or in an area of quasi-contract than it is to be under a contract. Because rather than being paid in accordance with your tender, you are paid a reasonable amount. And in some circumstances, that can be, in effect, cost plus. There is no completion date. There is no damages for delay. And indeed, they can't even charge you for the cost of repair more often than not. What they have to do is to do an abatement and not pay you for works that are not properly carried out. Now, I've acted for many subcontractors where that's exactly what's happened. And when the contract has been sought to put in place, behind the scenes, I've assisted the subcontract to avoid that subcontract being put in place by asking some very simple questions. In that you are now placing the subcontract some 6 months after we've started, there's problems associated with what that contract now places obligations upon us because we didn't do them. It says we've got to issue all these notices if we were delayed. And well, we were delayed at the start for variations, and I can't now do that retrospectively because it will say that I didn't do it as soon as reasonably possible, which the contract provides for. So I don't want to do that. And there's loads of other problems. How are we going to deal with that? Now, from reverse psychology, what I will do on behalf of the subcontractor is to say, we really want to sign this subcontract. We're really keen, but these are some of the problems that need to be addressed. And the contractor, being faced with these difficult questions and thinking that the subcontractor wants the subcontract in place, quite often go, I'll show them, and won't place it. And thereby we've achieved for the subcontractor the required aim. Because that contract generally will give far more benefits to the main contractor than it will to the subcontractor. Okay, we've now identified what is involved with the placement of a subcontract. What we now need to deal with the limitation periods. Now, under a subcontract, the subcontract can be placed in two forms, either under hand or under seal. Under seal states it's a deed and is generally signed by two directors of the company, or a director and a company secretary, or a stamp. It will generally say this is executed under seal as a deed. And the significance of that is that the limitation period is 12 years when compared with underhand. So let's just clarify what that means. You are a subcontractor, you're doing piling works, and your piling piles are defective, but nobody knows it. Ultimately, the building falls down because the piles are wrong. A party can take legal action for 6 years if it's underhand and 12 years if it's under deed. But when does this time run from? The answer is simple, from the date of PC. So a party, if it's underhand, can take action within 6 years of PC for any defect. What does it mean, though, to commence action? Well, it means to commence and issue a writ, for example, or an arbitration notice, or in theory, an adjudication notice. Otherwise, you will have a defence of statute barred. I no longer have any obligation. Now, this is happening a lot at the moment concerning cladding. Everybody who has a building of over 18 metres high and where they have concerns that the cladding as installed is not right, they are mindful of the limitation period. And where the limitation period is becoming close to coming to an end, they're suing everybody. And what they've got to determine is, have they taken the necessary action within 6 years or 12 years as applicable from the date of PC? So that's the limitation period. For subcontractors, quite obviously, it's far better to enter into a contract underhand. So you've only got 6 years liability than under deed. For main contractors, nearly all your main contractors will be under seal. So it is imperative that you place your subcontractors under seal 2. Now, when we have a subcontract, we have 2 forms of terms, those that are expressed, which is those that are agreed, and those that are implied, which are those that were not agreed. Not agreed, that seems a bit strange. Right, well, where you have an oral contract, it is any that you have agreed. Where it's an express contract, it's any of those that are written down in the contract. But there are certain things that will be implied into a contract, and they will be either from statute, custom, and statute would be an example of the Construction Act. If I have a subcontract that says the Construction Act will not apply, that is contrary to what the Construction Act says. And therefore, under the Construction Act, the scheme for construction contracts is imported. I have an obligation, if I'm carrying out works, to carry them out in accordance with building regulations. If the contract says, don't worry about building regulations, there'll be an implied term that I still have to comply with building regulations. So there will be no end of implied terms from statute. Other statutory provisions that are likely to apply are the Unfair Contract Terms Act, the Supply of Services and Goods Act, and there are many, many more. The express terms are those that are written in the contract or which have been agreed. As far as common law implied terms, common law being case law, terms are implied because of business efficacy. In other words, to make the contract work. A prime example is, I say to you, please carry out 10 meters squared, 10 meters of mastic. It's an offer for you to do it, and you then undertake it. You've accepted. But we've failed to agree how much you're going to be paid. But there is an agreement. What are you going to be paid? We get an implied term is a reasonable amount. When you take in your car for a service, there's a contract for the service to be undertaken. You haven't necessarily agreed what is to be paid. What is to be paid is a reasonable amount. We haven't said how long you're going to have to do it, so you've got to do it within a reasonable period of time. This term reasonableness comes from a case, it's called the wagon mount. But implied terms will only be imported to make business efficacy. In other words, to make the contract work. But they won't be imported where there has been a bad bargain or where the court simply cannot establish what should be imported. So if I ask you to carry out certain works, but I have not agreed what you are to carry out, the courts can't imply a term as to what you are to carry out. So there is no contract. And we're back into the same situation as letters of intent, where a party is entitled to a reasonable amount. And it is quasi-contract and restitution. I've got in the notes a number of standard implied terms that go into a building contract. However, some of these implied terms will not be implied if there is an express term to the contrary. Now, where you are placing a subcontract with a subcontractor using a standard form, make sure you use the up-to-date WUD and make sure you include all the necessary information in, for example, in the JCT, the contract particulars. You have to complete the form. If you include a form, but you fail to include all the provisions, you're going to have a problem. The common one I've often seen is that a subcontract is placed, but they make reference to a main contract. And the parties' names and references don't work. Well, it's going to fail, or it's going to at least make it very difficult to interpret. So the incorporation by reference of certain standard forms is problematic. Just dealing with incorporation, what you have when placing a subcontract is you have two things. You have either all the documents which the parties have signed, and you can point to them and you say that is the subcontract documents, or you can have a simple page which then lists out all the documents. And although you haven't signed those documents, by signing this one page, all those other documents are incorporated into the contract by reference. One thing I do find is all too often subcontracts are not put together properly. So be warned, contractors, because if you don't put them together properly, there's a possibility that either the subcontractor will be able to get out of some of those terms or possibly out of the contract altogether. Now, it's my experience quite often where the main contract ends up in dispute, so will the subcontractors. And it's a question when you're involved in adjudication, arbitration, or litigation, quite often the subcontractor doesn't get their rightful entitlement. And the reason for that is records. It's always the same. The person who ultimately wins is the person who has the best records. Now, I'm aware that, for example, mechanical and electrical subcontractors are generally very good with their record keeping, but some other subcontractors, because they simply do not have all the resources on site to keep adequate records, often fail. So you must keep adequate records. We're going to come back to records in a moment. Now, one thing that happens with regards to evidence and records is the use of the term without prejudice. I see this used all the time. And the idea of without prejudice means that the document that you are issuing on or without prejudice is privileged. It means it cannot be relied upon in any future legal proceedings, for example, an adjudication. And the whole idea of without prejudice is the courts are keen for the parties to seek to settle their disputes amicably and together and without any form of legal action. And to assist in this process, it means that if a person says, I'm willing to pay you £5 for that variation, you cannot then go to the court and go, they've accepted it as a variation. Look, they offered us £5. So by saying I'll offer you £5 on a without prejudice basis means I don't accept you're entitled to anything, and you cannot use this letter as evidence at all. But the point is you can only use the heading without prejudice effectively where it refers to negotiations. So in other words, if I say to you, you're useless on a without prejudice basis, it's not without prejudice, and it is an open letter because it's got nothing to do with negotiations. So wherever you send a letter without prejudice and it does not refer to negotiations, it is not without prejudice, notwithstanding its heading. But equally, if I say to you, I offered to pay you £5 on a without prejudice basis, and you come back and say, well, I'll accept £7, but you don't state without prejudice, the fact that you are referring to the previous offer I made, which was without prejudice, your letter remains privileged as well, because it is a whole list of correspondence, all starting from the without prejudice communication. And therefore, it's continuing along that line. Now, as far as subcontract is concerned, what I've done is to identify a number of provisions that are within subcontracts that can be onerous and you should look for as subcontractors. Dare I say it, it may be argued as contractors, you might use this as a basis of improving your subcontractor. Number one is non-compliance with the Construction Act. I quite often see subcontracts that are either old precedents that the contractor uses or have simply been poorly worded that fail to comply with the Construction Act. And just in case anybody hasn't heard of the Construction Act deals with two primary things. Number one is payment and number two is adjudication. As far as adjudication is concerned, the contract must provide for the right to go to adjudication at any time. So if it is a construction contract and it doesn't comply, you would still be able to go to adjudication even where the contract doesn't include such a provision. One exception to this is where the contract is in relation to works on someone's residential premises. But equally, where it is a construction contract, it must include certain payment provisions detailing what is to be paid and when, due dates and final dates of payment and payless notice, etc., etc. If it fails to comply, provisions from the scheme for construction contract are implied. And that can hugely change the whole nature of the subcontract. And most disputes all centre around whether payment and payless notices have been issued in due time. So do check your construction contracts, subcontracts, to see if they comply with subcontracts. I've got one before me at the moment, which is non-compliant because it ties retention to the release of retention under the main contract, which you can't do under the Construction Act, which therefore questions, well, when is retention due to be released? It's going to be uncertain. You're going to then look at case law and the Construction Act to try and determine it. But basically, it's non-compliant with the Construction Act. You need to read the terms of the contract. Where it is standard terms and their revisions, more often than not, they are going to be making that subcontract more onerous. Generally, in-house forms of contracts are the most onerous, so check them. Where it says you've got to complete by a completion date, but doesn't say what happens if you don't, then you have what is called general damages. What this means is that another party can recover the cost that they are incurred as a result of your breach. For example, prolongation costs, and provided they've given you full information when the contract was placed, the liquidated damages under the main contract. So check that one. It may include for extended payment periods. This is again relevant to the Construction Act. So check when you are going to be paid. Some people say that the final date for payment shall be 2 years after the due date. Suggest you don't accept that. Subcontractors, you need to establish if there is payment for unfixed materials and where the job is delayed, possibly for materials off-site. Check for condition precedent for payment. Conditions precedent means that you must have complied with this obligation before you are paid. An example is the NEC subcontract that says that 25% of monies due will be withheld until the first programme is issued and is accepted. So check for that. Excessive discount, obviously another one. Set-off arrangements. This is where a party can seek to charge you for costs that it incurs, but it could do it on the basis of forecast cost. So what our forecast would be, so we can set off our cost for your failure as forecasted. So you're the ground workers, the job's far from complete, they forecast that the ultimate job will finish 20 weeks late, and therefore they're charging you 20 weeks of liquidated damages that are forecast and have not yet even been incurred. Obviously, provisions for performance bond and warranties. Unless the contract provides for a warranty, you don't have to provide it. And unless the wording's agreed, it's an agreement to agree, which is unenforceable because you will never agree. The other one, too, that the ones that are most common you need to be careful on is obligations to suit the main contract's progress. And if properly put in, is what is called a beck and call contract, which means you've got to jump when they say jump. And if you don't, you're held responsible. So check that in your subcontractors. Excessive design responsibility. Taking the responsibility for the total design is not unusual and can be extremely onerous. And protecting your works until completion can be a huge problem as well. As far as subcontracting is concerned, the main thing, as I've identified before, is record keeping. Make sure you follow some of these very simple things. Make sure you apply for the works, application for payments on the proper dates with full and proper particulars. The more you're up to speed and issue the information to the contractor, more able they are to issue it up the line and hence get payment, and then they'll pay you. Whether you're entitled to the money is not always relevant. It's whether the contractor can recover that money themselves that creates the dispute. So make sure you issue applications on the right dates with full and proper particulars, not loads of amounts on account. Back up your amounts. Make sure you've got proper instructions. Take photographs of the works you've undertaken. Make sure your day work sheets are issued on time and are fully particularised. Make sure they're signed. The fact they've written across the front of it for record purpose only, I don't care. That's what a day work sheet is for. Record purposes. Doesn't mean you're entitled to be paid it. What we want to do is to record what was done. Take photos, most important thing. So far as delays is concerned, issue notices of delay and issue information. Simple rule, a notice of delay should be in a format that if you give it to your mum understands it. What's been caused the delay, why, who's responsible. If your mum wouldn't understand it, nor will the contractor. The contractor doesn't want to understand it. They want to say your notice is inadequate. Don't work on the basis, well, they should know. Well, they do know, and that's why they're not agreeing to it. Most of those things I've covered. Other things are site diary checklist. You should be keeping a site diary, ideally, on the project and keeping this level of detail. Payment we've already dealt with. Make sure you understand the payment provisions under the contract. Make sure it is compliant with the Construction Act. Many subcontracts I see are non-compliant. Delay costs we've dealt with as well. Most important thing on delay costs is photographs. Okay, cross set-offs. That is where the contractor can seek to charge you for monies that have been incurred on another job. So there's two subcontract orders, project 1 and project 2. Under project 1, he says you're in delay by 6 weeks, we've got no monies on you. On project 2, you're still completing those works, so rather than paying, he then charges you for project 1. They can do that if the subcontract provides for cross set-off. So don't agree to it. Future set-off, I've already stated. And the final provision in there is make sure that there is no provision within the contract that deals with deemed to agree. In other words, if you fail to respond within such a period of time, you've deemed to agreed it and it can no longer be opened. Now, I've covered a lot in a very short period of time. I hope that helps, but I imagine there may well be some questions. Julie, any questions?
There are indeed. Someone's asking, does the subcontractor order supersede all the tender's exclusions?
Well, it's back to the start. Not necessarily, because the subcontract order may not be a subcontract order. If the subcontract order has been signed or agreed to, that creates a contract, and then it depends on what that contract incorporates or not. And it could incorporate previous intent offers and everything. So what quite often happens is that the contractor, and this equally applies to employers, they're uncertain as to how to put the contract together. And where they're uncertain, they think, oh, the easiest thing is to include every piece of documentation that's ever been produced and include it all in the subcontract or main contract. And all of these documents then have to be read, and it's a question of which one takes priority and can create tremendous uncertainty. Other contracts have a clause that provides that any previous tenders of documentation are excluded and overwritten by the contract. So in simple answer to the question, I don't know, it will depend upon the facts.
Okay. Another question here is, how can adjudication be handled in a subcontract when the alleged breach also affects the parties to the main contract?
Some contracts have a joining provision that says that where the main contract's entering into a dispute with the employer and it affects the subcontractor can be joined into the same dispute. So in other words, there'll be a three-party dispute. It can also work the other way, where the contract says that where the subcontractor is in dispute with the main contractor can then bring in the employer, so the three parties are going to be in one dispute. But that is very uncommon. Most people, particularly contractors caught in the middle, do not want to be found involved in adjudication which is between three parties. So where it involves the employer, it's irrelevant to the subcontract because the subcontractor just looks under the subcontract itself. So if the subcontractor says they're taking action against the main contractor for the failures of the employer, the main contractor becomes responsible for those employer's failures and the subcontractor would succeed. And then it's a decision for the main contractor whether they take the necessary action up the line against the employer.
Okay. That seems to cover the questions we have for this morning. So thank you very much for your time as always, Richard. Very much appreciated. Thank you everyone for joining us on this lovely sunny Wednesday. I hope everyone has a good day. Our next seminar event will be next week when we are looking at project security with John Sharp, and that's at 8 AM on Wednesday. So if you would like to book a place on that seminar, please email me at seminars@silverllp.com, and we look forward to seeing you then. Thank you very much, everyone.
Thank you.
Thanks, Richard.
Hi, Jean. Just whilst remember on...
We're still live.
Oh, okay. All right, I'll speak to you later.
Okay, no problem. Thanks.